Naratu, can I proceed with the opening?
Yes, please go ahead.
Okay, good. Good morning, everybody, and our esteemed panel and all of our participants. My name is Antoni van Nieuwkerk. I'm a professor at the Wit School of Governance, which is hosting this particular conversation this morning. We want to explore privacy and security compliance. This relates to the latest POPI Act, and it affects not only the private sector, but the public sector and individuals. In fact, it affects all of us, and the school thought it would be important to play this educational role and invite members of the public, our students, our staff, WITS in general, to participate in this very important conversation. As you can deduce from the name of the School of Governance, we offer postgraduate degrees in all aspects of governance, from security, which is closely related to the conversation today, to public policy making, finance, development, and monitoring and evaluation. In fact, if you think about it, all these themes that I've just noted relates to the relationship between privacy and security compliance. So I think the school is well positioned to launch this exploratory discussion on the POPI Act. I'm very happy to say that one of the panelists is a former student of ours. I supervised him, in fact, so you are assured of a quality presentation. I'm also very happy to say I'm going to hand over to the facilitator, Vereen Etzebeth, who works at a sister school, School of Law, but she's a prospective PhD student here at the Wit School of Governance. So again, you will be in very good hands with the conversation and the esteemed panel, which she will introduce in a minute. Let me say one word about Vereen. She's a senior lecturer at WITS and a consultant working to better understand the interaction between information technology and the law. That is why she is the facilitator today. Her expertise includes information security, data protection and management, data analysis, and information technology law in general. I think Vereen is well placed to facilitate the conversation, and we have a wonderful panel which she will introduce, and I'm going to hand over to her now. Thank you very much and welcome to this conversation.
Thank you very much, Antoni. If I could introduce our esteemed panel. First of all, Advocate Pansy Tlakula. Pansy is the chairperson of the Information Regulator of South Africa. She has held high positions in academia, public and the private sector. These include National Director of Black Lawyers Association, one of the first commissioners in South Africa of the Human Rights Commission, the chairperson of the board and of the National Credit Regulator, chairperson of council of the then University of Northern West, and the chancellor of Vaal University of Technology. She was also independent non-executive director of Bidvest and the chief electoral official and later chairperson of the Electoral Commission of South Africa. Pansy is a former chairperson of the African Commission on Human Rights and People's Rights, and is a special rapporteur on freedom of expression and access to information in Africa. She is a member of the United Nations Committee on the Elimination of Racial Discrimination. Then we have D.V. Dromondru. He's on a mission to free the world of data breaches. D.V. has been developing security for over the past 2 years. He's worked extensively with technology titans, including Samsung, AT&T, Cisco, HP, Nokia, and Ericsson. His expertise spans security, networking, cloud, and data centers. DV is the founder of InfoSec Enforcer, and is a startup advisor, and he writes codes. He lives with his wife and daughter in Silicon Valley. Sibusiso Zulu, that we have with us today, is a specialist in integrated risk management solutions, including forensic investigations, crime research, and community safety audits. He has been involved in high-profile government-driven security projects, spanning from leading IT network vulnerabilities tests to information-driven social crime prevention. He has participated in programs promoting school safety, research, and community-based crime. Then Gavin McLaughlin is the Managing Director of Randall's. He's not new with us, unfortunately. He has been practicing since 1981 in the area of cyber law, privacy law, and property and housing. As a member of the National Department of Communications Advisory Panel on e-commerce, Gavin was involved in drafting the Green Paper on ICT policy. And then Paul Ace, who's with us today, is on a mission to safeguard cyberspace across South Africa. As the founder and CEO of Bowling Security, Paul works on major security and compliance programs right across South Africa. Now, these are our esteemed speakers, and I think we're going to learn a lot from them. Thank you also to everybody joining us live. If you have any questions, please post them on Facebook, and I will relay them back to our speakers so that they can answer all your questions. Here's the book. If you haven't seen the book, the poster is right behind us, and we're going to be talking about this valuable book, which actually gives a whole new perspective on POPIA. And it's interesting to hear how they got to this new perspective. If I can start off with the first question. Sorry? Yeah, Advocate Pansy. Can we switch over to you?
Yes, I'm here.
Do you want to start us off?
Oh, yes. Oh, thank you very much. Thank you for inviting me to this webinar. I also welcome in fact, before I say that, when the Dean introduced some of the panelists, he did indicate that one of them was his student. I think I should also mention that I was a student at VETS 40 years ago. I was just calculating. I was an LLB student in 1981. And one of the women who stayed at the Sunnyside residence when it was opened for the first time to Black students. So I thought it was important to mention this to say I'm also an alumni of the university. I have asked your colleagues there to share my screen. I have to welcome the book on POPIA, because I think it is important for us in South Africa to begin to build a body of knowledge on this new piece of legislation. And also I'm hoping, unfortunately, I haven't seen the book, it wasn't sent to me. I'm hoping that the book delves into the interpretation of POPIA instead of just, going through or mentioning the sections of the Act. Having said that, for the sake of the participants who do not know about the information regulator, this organization is established in terms of Section 39 of the Protection of Personal Information Act. And it is an independent institution. It is important to mention this because it is subject only to the law and the Constitution. The information regulator is not accountable to the executive, and it is not part of any government department. At the moment, of course, we are still under the Department of Justice and Correctional Services, we are using their systems and policies until such time we are able to be fully independent and establish our own systems. The information regulator has a dual mandate. It performs its functions in terms of POPIA and also is going to take over the enforcement of the protection of access to information, POPIA, from the South African Human Rights Commission. The regulator consists of 5 members who are appointed by the president, on, I just want to see if I didn't skip anything. No. Yeah, they're appointed by the president on the recommendation of the National Assembly. The process for appointing members of the regulator is transparent. It is the Portfolio Committee on Justice and Correctional Services in Parliament, which is responsible for the recruitment of members. They do that by publishing an advert in the newspaper to call for nominations, and people who are nominated will then, there will be a shortlist, and the shortlisted candidates will be interviewed by members of the committee in public, and thereafter the 5 members will be taken to the National Assembly, which has to vote on a simple majority for those members. The names of the 5 members will then be taken to the president, who is the appointing authority. The regulator accounts to the National Assembly, and members are appointed for a period of 5 years. Can we go to the next screen, please? The chairperson and 2 members of the regulator are full-time, and the 2 other members are part-time. And 1 member is appointed is designated for POPIA, and the other one for POPIA. We took office on the 1st of December 2016, which means that the 5-year period of the current members, it's going to come to an end in November this year, except for 1 member who was appointed in December last year to fill in a vacancy of a member who resigned. The regulator has quite a wide mandate, and the mandate is provided for in section 40 of the Act. I won't go into that in detail, simply to summarize that the mandate includes providing education, monitoring and enforcement, and enforcing compliance, consulting with interested party or parties on the Act. The regulator also handles complaints. It conducts research. Next screen, please. I think you're running a little bit behind me. I'm on screen number 5. Yes, I'm going to number 6. The regulator can also issue, amend or revoke codes of conduct. It can make guidelines to assist bodies to develop or apply for their codes of conduct. And the regulator can also enforce, facilitate cross-border cooperation in the enforcement of privacy laws. We can look at quickly the purpose of POPIA. We want to all the time emphasize the fact that we are a human rights body. I think it's important to say that ours is a human rights, a constitutional mandate. I have to emphasize this because I have seen in other parts of the world that our sister organizations look at themselves more as kind of ICT kinds of organization. And with us, it's important to emphasize the fact that we enforce a constitutional right to privacy by safeguarding the manner in which responsible parties process personal information. And we do that by balancing the right to privacy against other rights, such as the right of access to information, and to ensure that there is a free flow of information. I did not go into, in this presentation, into definitions. I made an assumption, and please pardon me if my assumption was wrong. I made an assumption that the people who will be joining would be, aware of the definitions, like who is the data subject, the data subject being the owner of the personal information, the responsible party is a person, or it is a private or public body that processes personal information. The definition of processing in the Act is also quite wide, includes collection, disseminating, collating, linking, merging, and so on. So I did not go into those definitions, but the terminology I will be using it throughout this presentation. The Act regulates the manner in which personal information is processed by responsible parties, who then have to comply with the 8 conditions for the lawful processing of personal information. Those 8 conditions are the minimum threshold requirements for the lawful processing of personal information. Of course, the Act also provides data subjects with rights and remedies to ensure that their personal information is protected, and it also establishes voluntary and compulsory measures, which include the establishment of the information regulator, which is the one that enforces, fulfills, and promotes the rights in that Act. The Act, in terms of Section 3, applies to the processing of personal information, which is entered into a record by or on behalf of a responsible party by using automated or non-automated means, provided that when recorded personal information is processed by non-automated means, then it will form part of the filing system of the information of the responsible party. It is important to emphasize the primacy of POPIA. It takes precedence over any other law that regulates personal information. The only law that will trump POPIA is the one that will provide more protection to data subjects than POPIA. It is important to say and to emphasize that POPIA does not prevent public or private bodies from exercising their powers or fulfilling their functions. I'm saying this because I have heard arguments that the law stifles innovation. It's going to make it difficult for public and private bodies to perform their functions. That's not the intention. The intention is to ensure that our privacy is protected by ensuring that our personal information is protected, because personal information is closely linked to our human dignity. No one has the right to do as they please with our personal information. You would also know that on the 1st of July, and this has been all over the media, all responsible parties must ensure that processing of personal information complies with POPIA. On this date, the enforcement powers of the regulator will come into effect. We have had questions like, will this date be extended? It will not be extended. You remember that this Act was passed in 2013, and the President brought into operation the rest of the sections of POPIA into effect in July last year. So I think South Africans have had a reasonably ample time to implement, to ensure that they put compliance processes in place. And on the 30th of June, we'll take over the enforcement of POPIA from the South African Human Rights Commission. And these dates are important so that you can be aware of them. On the 1st of July, Section 58 of POPIA shall become applicable. And this section talks about responsible parties who have to obtain prior authorization from the regulator if they intend to process certain types of personal information which are of high risk. The regulator, in terms of Section 112 of the Act, has the power to make regulations. Those regulations were made in 2018, and they will come into operation on the 1st of July, but some of those regulations have already come into operation. Regulation 5, that deals with the application for the regulator to issue a code of conduct, came into effect on the 1st of March and this year, and Regulation 4, which deals with responsibilities of information officers, came into operation on the 1st of May. Now, to just go into the content, how are responsible parties supposed to comply with this act? They comply with, to ensure that their processing complies with POPIA. POPIA provides or prescribes 8 conditions which any responsible party who processes personal information has to comply with. Of course, like any other piece of legislation, there are exclusions to this act. For instance, a person who processes personal information purely for domestic purposes. I mean, if as a natural person, if I process personal information for domestic purposes, to pay bills and so on, I don't have to comply with these 8 conditions. And it's important also to emphasize that within each of those 8 conditions, there is a built-in exception. So even if the 8 conditions apply, there are exceptions under which the conditions will not apply. I will not attempt to go into these conditions in detail because it's quite long. Safe to state that the first one is accountability, which simply means that the responsible party who processes personal information has to be accountable for that by ensuring that they comply with all the 8 conditions for the processing of personal information. And then processing limitation, within that, there are quite a number of sub-requirements. For instance, this means that the responsible party must ensure that they process personal information lawfully and in a reasonable manner, and they must only collect minimum information which they require for the purpose for which they are processing that personal information. Can give a concrete example. Those who most of the time we go and enter premises, or for instance, if you enter Wits University, at the gate there are security personnel who will require you to furnish personal information for the purpose of gaining access into campus. In some instances, I have a feeling that these gated communities or gated office premises process excessive personal information, because I have experienced situations where when I enter, I'm requested to give my name and surname, and then my ID or my driver's license is scanned. The disc on the screen of my vehicle, what is the word? It's I forget the word. Sorry. Scanned. That's the word that I want. They scan also my driver's license. They scan the disc as well. I mean, if you just imagine the disk and my license contain a lot of personal information. I don't know why that personal information is collected, because as far as I'm concerned, that's excessive processing of personal information. I think that for the purpose of entering an office block, probably all that is needed is my name and my surname, probably the registration of my car and the color of my car, because that will be able to identify who I am. So that's the requirement of minimality. And of course, personal information has to be collected with the consent of the data subject or a competent person who can give consent on behalf of a minor. Personal information has to be collected directly from the data subject. It has to be collected for a specific purpose, and the records of the personal information must be kept, and they must be retained, but also kept for the period for which that personal information was given, was provided. For instance, if I enter into a contract with a service provider for a mobile phone, they then have to keep the records of my personal information. But once I change or I stop that contract with them, they then have to ensure that they destroy my personal information, of course, subject to the laws that are applicable to destruction of records. And the personal information must be, if it is further processed, it means the further processing should comply with the original purpose for which that personal information was collected. We give the example of the Facebook, WhatsApp privacy, revised privacy, which is a matter that we are dealing with. We have given our personal information with consent to WhatsApp to enable them to provide us with their services. Now their revised policy says that they will then share our personal information with WhatsApp companies like Facebook. I think that's further processing. And further processing has to only take place with the consent of the data subject, and the further processing must be compatible with the original purpose for which the personal information was collected. The responsible party must take reasonable steps to ensure that the steps are taken to update the personal information of data subjects in their possession, to ensure that that personal information is accurate. And they must also keep documentation of the personal information that they process, and they must notify the data subject when they collect their personal information from another source. And the responsible party also has the responsibility to ensure that they put in place reasonable and adequate security measures to protect the personal information from unauthorized or unlawful access. And those security measures have to be technical and organizational security measures. If the responsible party outsources their processing processes to an operator, then they have to ensure that they enter into a contract with that operator to ensure that they will process the personal information in terms of the law. And then if the responsible party experiences a data breach, then they have to inform the regulator of the data breach. They also have to inform the data subjects, and then The last one is data participation. The data subject has the right to request free of charge the responsible party to provide him or her with information, personal information, which they have in their possession. I have just tried to summarize quite a lot of all the 8 conditions for the lawful processing of personal information. And I'm hoping that you can then, on your own, look at them in full. So all public and private bodies must put systems and processes in place to ensure compliance with the conditions for lawful processing of personal information. Maybe let me step back a little bit to say that condition that I spoke about, the condition of putting in place adequate and security measures to protect the integrity and confidentiality of the personal information. This is where you find the link between POPIA and cybersecurity, because on our side, the law requires a responsible party to put those processes in place, and failure to do that attracts fines. We can conduct an investigation, and if we feel after the investigation we come to the conclusion that the responsible party failed to put adequate and reasonable technical and organizational measure in place to protect the security of the information, that's where we come in. But if there is a crime that is attached to that, if there has been a cyber attack and so on, that's where the police come. But I mean, that's where our mandate come together. So what should responsible parties do to ensure that they comply with the Act? They have to understand, each responsible party, and I hope this is taking place, has to understand each of the 8 conditions for the processing of personal information. They have to ensure that they implement or they put activities and processes in place to implement each of those conditions. A responsible party has to perform what is called a data mapping exercise, which means that they must compile an inventory of all the personal information in its possession. And in compiling that inventory, the responsible party must distinguish between personal information and special personal information. The responsible party must audit the processes they use to process personal information in its possession. And in auditing that, they have to bear in mind the definition of processing. How do they process? Do they collect? Do they record? Do they store? Do they link, measure, merge, disseminate, and so on? And the responsible party must know the persons who have access to their personal information, how and where that personal information is stored. And they must ensure that that personal information is secured by putting in place appropriate security safeguards. Of course, the responsible party must put in place compliance governance structures. Of course, this will depend on the size and complexity of the organization, and also depending on the complex and organization and size, it might also help to appoint POPIA champions in each of the strategic departments or units. The responsible party must have retention and distraction policies, and they have to ensure that they train everyone. Everyone who processes personal information must be trained, and the training must include both the obligations of the responsible party and the rights of the data subject. The responsible party must also appoint information and deputy information officers who must be registered with the regulator. The regulator, in preparation for the 1st of July, has adopted a number of documents to assist with the implementation. This includes the guideline on the development of codes of conduct to assist bodies which intend to develop and apply for the issuance of a code of conduct by the regulator, because in terms of the act, certain bodies, professions, and so on can develop a code of conduct on how they are going to process personal information, and they have to, the regulator has to issue the code of conduct upon application. And we have also issued a guidance note on information officers and deputy information officers. Both POPIA and POPIA require public and private bodies to appoint an information officer or to designate or delegate a deputy information officer. So we've come up with this guidance note, which spells out who should apply, who should be appointed as an information officer, the duties and responsibilities of an information officer, delegation and designation of deputy information officer. The regulator has developed a portal to ensure that responsible parties can self-register their information and deputy information officers. That portal is live. The existing information officers who are appointed in terms of POPIA can only perform the POPIA functions after registering with the information officer. We have also issued a guidance note on prior authorization to guide responsible parties who want to obtain prior authorization before processing information provided for in section 57 to 58 of POPIA. And this is what in other jurisdictions is called high-risk personal information. We are in the process of finalizing a number of guidance notes, including the guidance note on exemptions for conditions for processing of personal information. And this will help bodies that want to apply for an exemption from complying with conditions for processing of personal information. We are developing and almost done with a guidance note on direct marketing and a guidance note on the meaning of appropriate and reasonable technical and organizational measures as provided for in section 19 of POPIA. As we know, challenges, as I almost rounding up, POPIA is a complex piece of legislation. It is new. We were appointed 4 years ago, 4.5. You can just imagine you are appointed, you are told you are now the chairperson of information regulator. You have to establish this from scratch. And at that time, all that you have is a copy of the legislation. So it's been quite a journey. We had to figure out what kind of organization we want. We had to think about the structure, the policies, even simple things like the logo. Just thinking of the logo, what do you want that logo to represent? Of course, and the challenge is that there is a dearth of data protection practitioners in South Africa, which means that all of us are learning on the go, and even those who have probably have some experience under the GDPR of Europe, they also have to learn because there are nuanced differences between POPIA and the GDPR. We therefore think that it is imperative for institutions of higher learning to offer courses, intensive courses, and produce experts in this area of the law. And just to give you some of the challenges that we have encountered in trying to apply a POPIA, I did speak that in terms of the law, in terms of section 57, responsible parties who process high-risk information must apply for prior authorization from the information regulator. Just to give an example, a responsible party who processes information for the purpose of credit reporting, they have to apply for prior authorization. I mean, if, for instance, vets, when you in your recruitment, you will you will advertise, interview, and the successful candidate has to go through a series of security checks to check whether they have a criminal record or not. The company that processes that personal information has to apply for prior authorization from the regulator. The question that, and we are at the moment dealing with applications for prior authorization. One of the issues that we are grappling with is that in considering an application for prior authorization, should we also inquire whether the responsible party has complied with all the 8 conditions for the lawful processing of personal information, or will this be regarded as ultra vires section 57 and 8? And also when it comes to exemptions, when you look at the section that deals with exemptions, it says that a public body will be exempted by, of course, by the regulator if it processes personal information for in the public interest, and that public interest trumps the privacy of a data subject to a substantive degree, and so on. And if you look at that section, it mentions issues like public interest. Public interest is not defined in the section, except that it's defined by reference to examples. It says public interest includes the interest of national security, interest of freedom of expression. We have to unpack that to say what does that mean. That is why I'm saying that institutions of higher learning have to assist us with just unpacking some of the concepts mentioned in the Act. Also in direct marketing, if you look at section 69 of POPIA, it prohibits processing of personal information of a data subject for the purpose of direct marketing through any form of electronic communication. We have had some stakeholders in the direct marketing sector telling us that direct marketing through phone calls that we receive from a call center does not constitute electronic, that does not constitute direct marketing through electronic communication. So as I conclude, I'm saying to you that we have big challenges, lots of challenges in the interpretation of POPIA as a new piece of legislation. So we look up to academic institutions to accelerate research on the interpretation of various sections of POPIA. And as you know, it's a new piece of legislation. We have to build jurisprudence. Our courts also have not dealt with this area of the law, which in this period is the emerging area of human rights, because data has become a currency for everything that we do globally. Thank you very much. I hope I've taken a lot of time, but I needed to do that. Thanks for your attention.
Thank you very much, Advocate. And perhaps to start off with, I know we're running a bit late, but just one question, POPIA is quite resource intensive. What do you think the main challenges would be for small to medium-sized businesses when they want to implement or start implementing POPIA?
I think training, I didn't hear, you said it's a high, I didn't hear your question at the end. Can you repeat? You
okay, I say that POPIA is quite resource intensive.
Oh yeah.
What are the main challenges for small to medium-sized businesses wanting to implement and become compliant with POPIA?
Of course, they have to get assistance to comply. We, as the regulator, to the best of our ability, we assist bodies, but we can't give legal advice because we are also the regulator. We can assist with some of the, education on how the Act works, how it fits in together. But I think we always advise responsible parties to ensure that they get experts who will assist them with compliance. And there are a lot out there who hold themselves out as experts. I'm saying that because we are all learning on the go. So no one can really hold themselves out as an expert in this area.
I think we're going to go over to the authors now, because
questions for advocates.
of our time. Okay, there's a question. Access control at residential estates and office parks rely on the driver having to hand over the driver's license, which gets scanned, and then that license is then containing their personal information, name, surname, ID number, residential address, contact number, and I believe a picture is taken as well. Are the security companies still going to be allowed to gather and store that type of personal information? And what happens if you don't want to hand over that level of information?
Yeah, you know, this is, in my presentation, I spoke about this. We as the regulator, we are of the opinion that what they do is excessive processing of personal information. And the security sector is one of the sectors that we have to engage. At this point in time, I think their attitude is that, look, this is a private property. If you want to enter into private property, this is what you have to give us. But I mean, even if that's private property, POPIA applies to them. There is no doubt in my mind that what they're doing is excessive processing. But as I'm saying, that the security sector and the sectors that do surveillance are sectors that we will have to engage quite soon.
So then there's another question. How would POPIA then be applied if POPI overrides all other acts?
Well, I didn't say it overrides. I said it trumps to other acts or legislation to the extent that POPIA provides more protection than that legislation. So if you have a piece of legislation that provides more protection of personal information than POPIA, then that piece of legislation will trump POPIA. But I can give an example, because it's good to talk about examples so that these things are not at a theoretical level. We have the National Consumer Act, for instance, that talks about, they have a section on direct marketing. They are compiling what they call an opt-out register. That opt-out register is really a register of all data subjects who do not want to be contacted by direct marketers. So if you are on that opt-out, you cannot be contacted. But our act says to be contacted for direct marketing purposes through unsolicited electronic communication, the data subject must consent, which means our act is opt-in, consent. Data subject must give consent to be contacted. So you can see that there is conflict between POPIA and the National Consumer Act. In our interpretation, POPIA should trump the National Consumer Act insofar as that issue is concerned.
And then there's a question, are we as an organization required to collect or consent to existing personal information, or is it only information that's collected from the 1st of July 2021?
Interesting. I think that, let me give another concrete example. A recruitment agency, for instance, will have CVs of people that they have recruited, they have headhunted, and if they want to continue to keep that personal information post 1 July, they then have to go back to those people that they had collected their personal information to say, do you still want us to keep your personal information? So that's how we think the Act should apply. Post 1, if you still want to process the personal information that you had collected before the 1st of July, you still have to get consent. Of course, this is all subject to whether an exception applies to you or not as a responsible party.
Then, as a full boarding school, we keep lots of information regarding minors, such as medical information, names, pictures, etc., which are used to keep the relevant parties to act in loco parentis as and when necessary. We obviously also take photos, report achievements, and publish these on social media, as well as in yearbooks. We have sent our consent forms to existing parents to consent to these, but some have come back not giving consent to the above. But the hampers that very crux of being a full boarding school and takes particularly of being able to share pictures for achievements. How do we approach these parents? Can we reject their consent or disallow the child in participating in activities with the school if their reasoning is not legitimate enough due to the impracticality thereof of trying to exclude them when these sorts of data is vital to the intention of being at the school?
Well, your line is not too good, and that's a very long question. And I was checking if it's on the screen. I can't find it. So, I mean, if schools want to continue to publish pictures of the children, they have to get consent from the parents. And I think that consent is not difficult. Is that, for instance, if you're going to take school photos, because these days, you know, parents will get a newsletter which says, we're going to be taking pictures of children on this particular date, and you have to pay and so on. You just have to have a consent block, you know, to say, when you pay for that, you also say, yes, I agree. In fact, you did that here for a recording of this session. Yeah. Before we started, there was a block that says, do you want to continue? Although I'm not sure whether that is a voluntary consent, because the block that you issued was whether if you click continue, you will be recorded, and that you are not asking me whether I want to be recorded, do I consent to be recorded or not. I think these are some of the issues that, we need a paradigm shift in the way in which we've been doing things.
Okay, and then last one. Can I ask you whether you think the Act is short on documentation required for businesses? The GDPR is much stronger in requiring data controllers to keep documentation.
Well, there is a section on documentation, and we encourage our people. GDPR does not apply in South Africa, by the way. So we hear all the time people referring to GDPR. We are not Europe. So responsible parties must study this act and ensure that they comply with it. They can't tell us that because we comply with GDPR, we are compliant. I saw a question here. There is a section on documentation. As to whether that section is strong enough or not comparable to GDPR, we have what we have. GDPR, for instance, and I saw a question on the screen, and which is something that we are grappling with, because POPIA is one of the few, if not only, legislation that protects data or personal information of juristic persons where appropriate. And of course, a juristic person, I'm sure, has its own personal data in terms of its name, its addresses, and so on. But that's another area, as academics were saying, we have to unpack on that issue to say, how does POPIA protect data of juristic persons? Because there's no jurisprudence that you can find anywhere. We have to struggle with this and find meaning to it as we go.
Thank you very much, Advocate Pansy. Now we're going to go over to one of our authors, and he's going to give us a presentation on the book to lead us into it.
Thank you, Advocate Everin. My name is Moses Okibu. I'm one of the authors.
So the sound is gone.
We
The
can't hear
sound
you.
is gone. We can't hear you.
Can you hear me now, Advocate?
Yes, we can.
Oh, thank you. No, I just wanted to cover the issues that are not explicitly stated in the book that we have also considered. One is the issue of the POPI Act, the compliance part as a business disruption. It's business disruption in the sense that we have to do business in a new way now. It's no longer business as usual. We have arrived at the new moment as the dates have been articulated. The 1st of July 2021 will change the business landscape. The second issue that we wanted to highlight as well is the question of the workplace environment, as well as the people's management issues. Those are also embedded in the workplace situations, and we need also to address that. For instance, the question of resistance to change that will happen. Shock, anxiety, those are the issues that we need to deal with. So change management is essential in the implementation of POPI Act compliance. The other issue that we need to look at from the business perspective now is the question of the maturity of technology used in various businesses. We are not at the same level in terms of technology advancements. That could also create another challenge. The last thing that I want to mention before handing over to DB for the presentation is that this new moment, this new normal will require us to develop new competencies. And we should also be in a position of harmonizing the human competencies with the digital resources so that the one does not replace the other. We have a situation where we are able to exploit both the human competencies as well as digital resources. And those are the few issues Advocate Marine that I wanted to cover, that we have given consideration to such. And I will hand over now to DB to take us through the presentation in terms of why did we write the book in the first instance, why did we go for the perspective that we have adopted, and then we will also cover some of the issues that have been raised. I heard Advocate Tlakula that you have not received the copy of the book. We will ensure that the copy is delivered to your office. We will leave few copies with the university here, and surely Lerato will find a way of getting them over to your office. I thank you, Advocate.
Okay, Debbie, you can go ahead.
Thank you. I hope you can see my screen.
Yes.
Thank you. Thank you very much. A very big panel today. Appreciate it that Advocate Tlakula is here with us. Thank you for your insight in a number of things that we talked about. I just want to quickly go over this. I think there's a lot of questions. I think we should address those more importantly than discuss the book itself. But I want to give you an idea about why we started to do this. Why we wrote the book is very, very simple. We could not, when we looked at the Act itself, when we looked at the draft regulations and the regulations about the information officers that have been written up in the guidelines for the information officers that were written, we basically thought that it needed a step-by-step guide. Something simple as do A, do B, do C. So it would have been very easy to follow that. And we wanted to reduce the complexity and potentially confusion associated with some of the stuff. We wanted to make it easy so it could be a process-oriented effort and governance could be implemented in an organization. And we could also start to look at how to mitigate the risk associated with POPI compliance. Okay. So we took 3 guiding principles out of the entire stuff, right? Number one, and most important, I think we discussed extensively, is about respecting the privacy rights. So if you think about, if you, in your organization, if you think about your own personal information, how would you treat your own personal information? And why don't you treat that information similar to how you would treat your customer information or your vendor information or any juristic personal information? Think from that simple angle. We wanted to simplify how you think about this. Also think about protection of personal data. You obviously do not want your personal information in the dark web. And similarly, you don't want your customers' personal information in the dark webs. Same principles apply, right? And of course, process data lawfully. Here, I think there's the issue of special personal information that was referred to during the presentation by Advocate Tlakula. And think about it this way: if you are not a healthcare provider, why do you need to collect information about lab reports or lab tests being conducted? That's not useful information, and you do not need that information about that. So those are the 3 guiding principles. And there's a lot of questions that we have seen about: does it apply to non-NGOs? Does it apply to insurance sector and this sector and that sector? It applies to all types of entities across board. Okay. Now, having said that, the way to think about implementation is very simple. Think about it from the point of view of intersection of where the legal aspect comes into play and the security aspect comes into play, and where your data collection aspect comes into play. When you think about that as a framework, you start to talk about what should your privacy policy be as an organization. What kind of just-in-time notices do you need to do? Where do you get and how do you get consent? Opt-ins, opt-outs, things like that. Obviously, we talked extensively about data subject access rights. We did talk, we may not have talked significantly about data protection because of cybersecurity elements of it involved. That's really important. When you think about data protection, you should also start to think about, and this is what we write in the book, should also start to think about access to data. Think about who in your organization requires access to data, personal information, who does not require access to personal information. In that way, you can at least reduce the risk vector that you have across the organization. If you are a 10,000, 20,000 people organization, or even 1,000 people organization, think about reducing the risk vector with respect to protection of data. Okay. Now, I think we'll skip this over. We all understand the risk. But the biggest risk that I typically talk about with many companies and businesses is about data breach costs. Okay, this is the bigger element of it. Nothing, I mean, obviously, non-compliance have fines and things like that associated with it. But so I want to leave it there. So, but how do you manage those risks? The way to manage those risks and the way to mitigate those risks, the most important thing that I have been talking to a number of businesses about is get started. If you have not done anything, that is the biggest risk. Do something. That's the most important element of it from a takeaway point of view. But again, we talked about mapping your data. But think, in addition to thinking about what your data is, you need to also think about the flow of your data. Okay, where are you collecting your data? How are you collecting your data? Are you transferring that data to some other third party, like your vendors, or putting out on a website, or sitting in the cloud storage that may or may not belong to you? You know, things like that. You need to conduct that flow aspect of it, not just know what it is, know where it is going from what place to what place. Also, think in terms of life cycle of your data. That's how you would know your risks. We talked about respecting consumer rights, and we also talk about downstream, you know, long-term perspective is to optimize how you do privacy operations, right? How do you secure your data? How do you automate access to data, you know, and as such, you know, potentially save a lot of money downstream. Okay. Now, having said that, what should you do? As I said before, simple, pragmatic approaches. Don't try to boil the ocean, right? You know, just go step 1, step 2, step 3. You know, in a few weeks, you should get maybe some of the essential things that you require done, and then talk about, you know, mid to long term, securing your data, and then data processing, automation considerations that you might have across your organization, right? We do provide, you know, POPI compliance software. The main element of it is to do with managing the DSAR, the data subject access requests, and the privacy rights aspect of it. Consent management comes into play in that as well. Data flow cataloging, vendor assessing the risk of your vendors, and also look at, you know, how do you do security assessments and breach prevention overall, right? By the way, this is not end all means all, okay? But think about it from the perspective of what we talked about: process, governance. You know, technology helps you only so far. You need to put process in place in order to help do that. Okay. Obviously, we are one of the few full service provider. We provide the security piece as well as enough automation associated with it in the market. And we are helping a number of companies with our software. We actually trained a POPI analyst that can sit and help you go through that within your process. So excellent with respect to how they can assist you with respect to your specific situation. Having said that, we also provide a free software package. You can just sign up. And if you have any questions, you know, Carl will be able to assist you with that. Okay. Having said that, over to you, moderator.
A very comprehensive summary. I think we're going to take some questions now. Let's have a look at, where would you say, what's the first step an organization need to undertake for POPI Act compliance? Say, imagine they haven't done anything. They've been on another planet, and today they step into your office and say, we haven't done anything. The 1st of July is upon us. What should we do? What is the first step you think they should take?
You know, we've done a number of businesses getting ready for it. The first thing we always say is know where your data is. What we mean by that is typically start to list your data assets. You don't have to go into specific detail of whether you're collecting a name, whether you're collecting the driver's license number, or any of that stuff. Just get a list of all the assets. Just write them down. We have a customer relationship management system, or we have we use G Drive or file storage. You have a cabinet full of paper. Just list that all together, and then think about how and where you collected that information. That would be the first step, which is nothing but data mapping, so to say. It's big words for simple actions, right?
And this is a very important question. And I think a lot of people are going to try and make a buck of this, but is there a way to get certification for POPI compliance? Does the information regulator, for instance, provide certification?
I think I would have Advocate Tlakula answer that question. I think I know the answer for that, but
No, we don't issue any certificates, because that will be a conflict of interest. If we certify you and then we get a complaint against you, how can we then adjudicate that complaint when we are actually endorsing you to say you're good? No, we don't certify anybody. Nothing.
So those companies that offer certification, because I've seen a few of them, they're really actually scams that are just trying to make a quick buck.
That's right.
Well, I mean, the issue.
She won't say it. I would say it.
What is it worth? That certificate, what is it worth? How is it going to? Because if we receive a complaint against you, even if you have that certificate, it means nothing to us. And I think another thing that we have to say is that we've seen that companies charge a lot of money for nothing. I see people go to firms of attorneys for registration of information officers. I don't know why they do that. They can simply go to the portal and register themselves. And if there are problems with registration, like I saw one of the questions here, that the system, as we have developed it, only allows one information officer to register per one company. That's how we build it, because we envisage the situation where if you are, say, a holding company with subsidiaries, the group CEO for the holding company will be, by operation of the law actually, is the information officer, and they can, of course, authorize someone else in the company to act as an information officer. And the subsidiaries would have their MDs and so on, and those will be the information officers at that level. But as I indicated, that this is all new. We are implementing. We wrote the guidance note, and that's how we thought it would apply, also because we're giving effect to what is in the law. So the application then shows us something else. We have companies that have subsidiaries or units, and you have only, like fund management, you only have one CEO who's responsible for everything. So what we are doing, we are collecting all the anomalies, the ambiguities. If there's something that doesn't quite work out for you, you write to us. We are going to have the second phase of the development of the portal, and we'll address all the issues that people have brought to us. I think it's important to say that.
And then, Advocate, there's another question for you, an interesting one I had yesterday. They ask, if we take out cyber insurance, will it guard us against fines and imprisonment? Well, I told them imprisonment definitely not. But will it offer them some protection? Will it offer some protection for the fines?
I'm going
People are getting creative now.
To respond to that question, because I don't know. I mean, I just like how people have become creative and the entrepreneurial spirit out there. And it's good to say there's a new piece of legislation. How can we make sure we make money? Cybersecurity insurance, you can still be breached, let me tell you, because no one is immune from from experiencing a data breach. But
And then the burning question I have to ask you, what's up with WhatsApp? I've read now, you know, the public announcement that you brought up, and how they say that POPI isn't equal to the EU, and that's why they differentiate between the two pieces of legislation. What, if you look in your crystal ball, is going to happen in the very near future? What are the plans of what are your office to deal with this WhatsApp crisis, because it is becoming a crisis?
Well, we're doing a couple of things, because we are mindful of the fact that we are just tiny entity, you know. It's a Goliath versus, is it Samson? Is that what it is? I can't.
Samson. David,
Samson,
sorry.
David.
Goliath. Yes, that's the situation. So we have to be strategic. On our side, I won't deal with the legal issues, because we are considering our legal options, because we have hit a situation where there's no agreement between us and them on the interpretation of our law. So the legal processes, we are continuing with them. But at a strategic level, you know, we are members of the Network for African Data Protection Authorities, and as a network, we wrote to WhatsApp, and we have also written to the Global Privacy Assembly, and we are a member. And these are Data Protection Authorities is an association at a global level, and we are a member. We have written to them as well to say this is an issue. We need to tackle this issue, all of us, you know, and they've written back, and we are looking at strategies to do that, considering that our legal frameworks are not the same, but the principles are the same. Further processing of our personal information without our consent, because the consent that they want us to give, they put a gun on our heads and say, yes, you consent. If you don't consent, leave, or we board you off. And it can be.
Load it and they pull the trigger.
But I just think they have pulled back a bit.
Yeah.
I think they were supposed to go to Parliament. I saw that they pulled out of that. They say they've not pulled out. They just have postponed. So we'll see. We wrote also to the Portfolio Committee to say, if you're calling them, because the Portfolio Committee had announced that they will talk about issues of misinformation and so on, particularly in the light of the forthcoming election and the data breaches that they have experienced. And we said, in addition to that, they also have to answer to the compliance of their privacy policies with POPIA and tell us why they think our privacy is less important than the privacy of the people who are governed by the GDPR.
And then perhaps just in closing, I want your honest opinion. How does POPIA compare to other international legislation like the UK Privacy Act, the POPIA, you know, the GDPR? Do you think we're behind? Are we getting there? How do you think we compare?
I think we compare favorably well. I think POPIA can stand, it compares quite favorably, but as I indicated that there are actually nuanced differences. I pointed out to the one of juristic persons being classified as data subjects and so on. But I think on the whole, the framework is the same.
I think it's slightly better than a number of things that I have seen, especially because I believe POPIA has teeth, so to say. GDPR has very slippery slope. It's very tough to, from an enforcement point of view, it's more difficult, and from an enforcement point of view, POPI is slightly better. And that's a big difference. And I think many people miss one thing, which is the name of the act itself: protection of personal information. The protection was actually written right in the title. Okay, that's the key element of it that I feel that is different substantially in POPI.
Yes, can I make a closing statement? I think because we talk about POPIA and more POPIA becomes the poor cousin of POPIA. And it shouldn't be. I'm a right to know activist. You saw that I was a special rapporteur on access to information in Africa. So to say that with the South African Human Rights Commission enforcing POPIA, they encountered a lot of challenges because they were simply just ignored when requests were made and when, you know, bodies did not just comply. That era is coming to an end. Non-compliance with POPIA is also going to attract sanctions. Non-compliance will go to the enforcement committee. So I'm just saying that people should be aware of that. There are consequences for non-compliance with both pieces of legislation, POPIA and POPIA. I thought I should make that point as well.
Then I have for the authors a question here. We work a lot with vendors and suppliers in my organization. Who will be accountable for the data protection of the vendor and the supplier? So I send personal information to them. I get personal information from them. Who would you say would be responsible?
So
who are you asking? Oh, go ahead, please.
Yeah, I'll take that. You know, it's easier. The vendors are responsible for protection of the data that is under their control, obviously. Now, but that doesn't imply that the business shirks the responsibility because they are the collecting authority, right? They are collecting the information. So the business also needs to have a type of agreement with the vendor that they would protect the data and they would be compliant with POPI. So our recommendation would be just engage your vendors, do an amendment with them, or do mention that they would, from a contractual perspective, right? It's much easier to do it that way, and maybe do some risk assessment on vendors and potentially downstream, maybe not available now, but maybe some kind of monitoring on what they're doing, maybe a quarterly business review or an annual review that a business and organization can conduct about the vendors. Again, it's about process, focus on process.
Divi, and then if I can ask you perhaps the last question here, do you think we can fully automate POPI compliance, POPIA compliance?
That's tough. That's very tough. Okay, just take an example of any business that has data. They have data everywhere. Data is new oil, and it is slippery. It goes from point A to point B without your knowledge. So it's very, very difficult, especially from like Advocate Tlakula was talking about POPIA, right? Where is my data? If a consumer comes and asks you, give me my data, where is it? You know, for you to go look for data in the entire organization, it's a really big task. It doesn't mean that you cannot figure it out. You can figure it out, but it takes time, effort, and a lot of budget. So full automation is something that I would not recommend attempting right now. You should try and attempt it over a period of time. Initially, just start to figure out where your data is and start mapping it.
Okay, and then we move on to one of our authors that's here, present here. If you can tell us how you decided on the best practices in your book for compliance, the reasoning behind that chapter.
Can everyone hear?
Yes, we can hear you.
Okay. Good afternoon, colleagues. Thank you, Advocate Tlakula. Thanks, Stevie. Thank you to all the participants as well. From a reasonable security perspective, I think the approach that we took is to look at primarily what constitutes confidential information, and then put together the best practices around that, because there's information out there that only needs to be shared with those who it's intended for. And then we looked at integrity of information. How can we assure that the trueness of information exists? And when it is manipulated, is it authorized manipulation or is it not authorized manipulation of data? And then the aspect of availability of information is always important when we look at reasonable security measures. So with that and a combination of best practices across the world for securing or protecting information, reasonable steps will be measured on how we look at information security. So the confidentiality of information, and this is clearly outlined in Chapter 10, the integrity of information and the availability of information. We want to make sure that all the readers of the book, as well as every responsible information officer for any organization, understands the CIA, not the organization that is deemed to be spying on us, but the attributes or the most important attributes of information. You know, if DV or Mr. Tulu or advocates, you would like to contribute to that explanation of how we put together reasonable security safeguards in the book itself. DV?
Okay, thank you, Carl. I think you know, we understand the CIA aspect of it, absolutely. And the definition of reasonable security obviously is different for, again, it's period dependent. Today, what is the definition of reasonable security is different from what it was 5-10 years ago, and it keeps changing. I think the Act having those words of reasonable security in them is really important and useful because of that changing condition associated with it. Obviously, the first thing that most security professionals in an organization absolutely know, one thing, you know, good passwords, you know, number one aspect of it. Do you have that, right? Do you make sure that your security controls are good, you know? So what we tend to do is, there are multiple standards, and what we tend to do is we tend to advocate what is called CIS 20 security controls assessment as a standard. So you can assess against your CIS, whatever your current organization security is, you can assess against those standards and find out they may not be, you know, very high on all aspects of those 20 controls that you would have, but you need to be reasonable in those controls, because for you to have a Fort Knox type of approach, like a Department of Defense or any other, right, or any other large cybersecurity organization, that's going to be very expensive. So you need to balance your budget versus what reasonable nature of security would mean. So we would recommend CIS 20 security controls being the aspect of reasonability there.
Thank you very much.
Sorry, I indicated that we'll be developing a guidance note, actually. Reasonableness, I think it's easier, but appropriate, I think, because the Act uses both appropriate and reasonable. So we're going to look at that. If you allow me, I just saw two questions about whether POPI applies to company information that is collected. Yes, because we said a juristic person will, under certain circumstances, be regarded as a data subject. So if you collect personal information of a juristic person, of a company, you have to ensure that you treat it the same as that of natural persons. And then are deputy information officers provided for registration on the portal? Yes, the question is yes, they have to be registered as well. Thank you.
And somebody has asked a question saying, is someone going to answer or address the questions that are not being answered? You know, I think I would leave it to the moderator.
We have some good news that 5 books are going to be given away to our listeners on Facebook, and to be notified who you are. So congratulations on that. Thank you guys, esteemed panel, for a very, very good discussion. I think we could have been here for another 2 hours and still have more questions. But thank you for this, for your time, and I hope you found it insightful. And please, if you have any other questions, visit our Facebook page, post it. We'll look at it, try and answer it. We'll send it to the authors. They can try and answer it. And have a lovely weekend. Thank you very much.